Hi everyone, welcome to Legal Talks by Desi Kanun. I am Suyash and I am excited to have started this show. On today's show, we will talk about another judicial pronouncement by the Honorable Supreme Court in relation to extension of period of limitation due to Covid-19 pandemic. As many of us must be knowing that in March 2020, the Honorable Supreme Court passed an order stating that the period of limitation prescribed under various laws shall remain suspended or shall be extended till further orders. By order dated 27/3/2020, the Honorable Supreme Court had extended the period of limitation prescribed under the general law or special laws, whether compoundable or not, with effect from 15th March 2020 till further orders. The court also observed that though the end of the pandemic remains to be seen, yet there seems to be considerable improvement in the state of affairs, and it is of the opinion that the order extending the period of limitation that was passed in March 2020 has served its purpose and there is no requirement to extend the same now. Thus, in light of all this, the court pronounced four important directions. Firstly, it is stated that in computing the period of limitation for any suit, appeal, application or proceeding, the period from 15/3/2020 till 14/3/2021 shall stand excluded. Secondly, in cases where the limitation would have expired during the period between 15th of March 2020 till 14th of March 2021, all persons shall have a limitation period of 90 days from 15th of March 2021. Thus, where the limitation has expired, then in such cases, there shall be a grace period or a further extension period of 90 days from 15th of March 2021. And in the event the actual balance period of limitation remaining with effect from 15th of March 2021 is greater than 90 days, then that longer period shall apply. The court also gave clarifications with respect to various provisions of the Arbitration and Conciliation Act and the Negotiable Instruments Act. And the court said that such exclusion of period of limitation will also be applicable on these special provisions, such as Section 138 of the Negotiable Instruments Act. Lastly, the court also made an interesting remark that the state has to allow regulated movement for legal, medical, educational and employment related purposes and requirements. I think this is a welcome move. So what are my concluding remarks? To be honest, though it is a small and a laconic order which we are analyzing currently, yet its significance is immense because it relates to the computation of period of limitation. There is a lot of confusion among the litigants as well as the legal fraternity regarding this computation of period of limitation. And this conundrum is started right from the order dated 24th of March 2020 passed by the Ministry of Home Affairs in exercise of the powers under the Disaster Management Act 2005. And by this order, lockdown was imposed and subsequently many more orders were passed and the lockdown was extended in a similar manner. Thereafter, after few months, the government started calling the same guidelines under the Disaster Management Act as unlock guidelines, though the term unlock has not been defined anywhere. Thus, in light of these confusions that have been taking place, the present order by the Honorable Supreme Court provides much needed relief and clarity to everyone by making it amply clear that the period of last 1 year shall be excluded for the purposes of computing the period of limitation. So I hope you enjoyed listening to this show. See you next time. Till then, stay tuned.